Well, good morning, everyone. This is George Spees for the Pennsylvania Office of Open Records. It's a pleasure to be here this morning with you while we're going to be discussing basics of the right to know law with our webinar this morning. A couple preliminaries to get out of the way. First offhand, if you'd like, if you've ever attended one of these webinars before, you know that the format is such that we have a PowerPoint on the screen with me talking in the background as we proceed through the presentation. If you'd like a copy of the PowerPoint, you can find that on our website. Go to the training tab and scroll down and you'll find resources there. And all of the PowerPoints that we use for our trainings are available for you on that page. You can download that and use it at your leisure, or you can follow along today or whatever works for you. Feel free to have at it. Pardon me, I've got a bit of a cold here that I'm getting over. Also, this session is being recorded. So if you'd like a copy of the recording, either for your future reference, or say you have a colleague who couldn't make it this morning, or you'd like to conduct, some training of your own, the recording is available. Contact our office and they will send you a link to a file sharing service, which would allow you then to download the recording. If by some chance your system, your security wouldn't allow you to access the file sharing service, you could send us a flash drive along with a note saying which recording you want and a self-addressed stamped return envelope, and we'd be happy to make a copy for you and send that back as well. If you have questions today, feel free to type them in the chat feature, and I'll do my best to answer them as we're going through the presentation. Two things. I'll ask that, number one, you keep your questions on topic. We're talking about the right to know law today, so hopefully your questions will be about that. Also, if you can keep your questions as concise as possible, that would be helpful. Honestly, sometimes it's a little difficult for me to sit here and read through a couple paragraphs that someone has typed in. It's a little awkward for everybody else to sit there patiently. If you have a situation that is unusually complex or specific to your agency, what we'll do is one of two things. We'll wait until the end of the presentation and I'll come back to it and try and get you steered in the right direction, or we'll take the conversation offline and we'll give you, the phone numbers on the screen right now, along with our website where you can find various email accounts that you can contact us, and we'll put you in touch with, senior staff, perhaps an appeals officer, who can answer your hypothetical and again get you steered in the right direction. Okay. Sorry about this cough I have. So all of that out of the way, let's jump into our presentation on basics of the right to know law. Okay, why is it important? Well, it represents, access to government, transparency, and good government overall. And I want to emphasize that, with this foundational statement that I like to begin the presentations with, and that is that the purpose of Pennsylvania's right to know law is to give the public access to public records. Okay, seems rather basic, but you'd be surprised how many people on both sides of the equation, the agencies and the public, misunderstand the purpose of the right to know law. I think sometimes we see that phrase or that title, right to know, and it's interpreted as some sort of Google for government, where people can ask questions and government's expected to run around and find out the answer for them. And that's just not the case. A lot of times when you've received a right to know request and it might not be clear what the person's asking for or what your next step is, I think it's helpful to come back to this foundational statement and think, okay, this is a right to know request. The purpose of the law is to provide public records. And that's your starting point, okay? And that can usually get you on the right track then with figuring out how to respond to a right to know request. Now, when you receive a right to know request, and understand, I'm kind of talking and presenting as if everyone out there is with the agency, but I do realize that we commonly have some folks who are, concerned citizens, they're activists or whatever, and they're invited to sit in on these sessions. Be as if I'm presenting to mostly agency folks for their benefit. But the starting point when you receive a right to know request is that every record of an agency is presumed to be public. Okay, that is somewhat of an overwhelming statement for some folks, but it is your starting point. Now, what I want to say is that, you get your first right to know request, or maybe you're new to the job and you hear this being said, and it's somewhat overwhelming. You think, oh my gosh, everything in the office could end up on the front page of tomorrow's paper, or, perhaps on someone's Facebook page or something like that. And I'm here to tell you that that's not the case, that as we proceed through the presentation this morning, there are a number of tools that are built into the right to know law itself, as well as other laws, that will protect records from public disclosure if there is a legal basis for withholding them. And that brings us to our second point, in that agencies, meaning your cities, townships, boroughs, authorities, school districts, and the like, agencies bear the burden of proving that a record should not be released into the public domain. And that is a legal burden. Okay, so if you receive a right to know request and, a red flag goes up, you're thinking, I don't know, this just doesn't feel right. I'm not sure I would release this, into the public domain because of privacy issues or security or whatever. There is a very good chance that one of these tools that we'll outline here this morning is available that you could use to meet your legal burden to show that a record should not be released into the public. If not, then there's a good chance that it is a public record. But we're going to talk about all these tools available this morning. So, key takeaway from this slide, twofold. One is that your starting point is every record we have is presumed to be public. Unless, and this brings us to the second point, the agency can meet its burden to show otherwise, that it is not a public record. The requester bears no burden, okay? It's totally on the agency. Okay, another point that I think we need to emphasize here is the fact that the right to know law is not a confidentiality law. Okay, what does that mean? Well, first offhand, you can give out public records without using the right to know law. So, hypothetical here. Let's say it's budget season, and within our office, we have a stack of proposed budgets, and I come walking in and I ask you for a copy of the budget. Okay, there is nothing in the right to know law that says you can't simply hand me a copy of that budget. I don't need a right to know request to get an otherwise public record unless the agency determines that they're going to have that requirement. Okay, there's nothing in the right to know law that demands or directs that I need a right to know request to get a public record. But if I have a right to know request, then you have to follow the process, unless the requester agrees to set the process aside. So let's modify our hypothetical. Let's say this time I come into your office with a right to know request, and it's asking for a copy of the budget. Well, you've got a stack of budgets sitting there. There's nothing in the right to know law that prevents you from saying, George, here's a stack of budgets. I can simply give you one if you agree to tear up your right to know request. Now, from my perspective, why wouldn't I do that? I mean, I'm getting what I'm asking for. And you're saving yourselves a lot of paperwork, a lot of labor, and I'm getting what I want right away. That's saving me time. Okay, so you can do that. You can say, look, we'll simply give you the record you're seeking if you withdraw your right to know request. Now, like I said, you can require a right to know request for accessing a public record if you deem that's necessary. What we recommend, though, is that you post the most commonly sought records on your website or whatever social media tools you might have available. And by taking this proactive approach, you're saving yourself a lot of time and a lot of effort. It may require a little bit more work up front, but in the long run, it will save you a great degree of labor and hassle. And it's more reflective simply of what government today is expected to do. So what we recommend is take a look at your right to know requests and what are people asking for? Identify the trends, identify the metrics that would identify those records that you could put on your website, such as budgets, contracts, salary information, purchasing documents, records that are clearly public, with no question. Put those on your website. Then what happens is next time you receive a right to know request, your response can be, that record is on our website, here's the link. And under the right to know law, that's considered a completely valid response. And what you'll notice is that people are much more comfortable sitting in their family room, searching your website for the records that they need, rather than potentially taking off an afternoon, filling out a right to know request, coming down to the office, and perhaps waiting over a month to get the records that they're seeking. Put them on your website. It's going to save you a lot of time, a lot of labor, and it's simply better customer service. So that would be our recommendation as a best practice there. Okay, so we're assuming you're here from an agency because you are subject to the right to know law. There are some things that you have to do. First, and probably most importantly, is that you need to appoint an agency open records officer, what we call an ARO. This is the person responsible for receiving right to know requests, processing them, and responding. Now, there's no requirement that the person be of a certain level within the organization, only that they be either an employee or a government official, meaning elected. Also, solicitors can serve as right to know officers if necessary. And when I use the term right to know officer, it's the same as an agency open records officer. The two titles are interchangeable. It could be, I could walk into a school district and, there are many school districts where the superintendent serves as the ARO. But by the same token, there are just as many school districts where it could be the lady sitting at the front desk in the administration building. Okay, there's no requirement that it be of a certain level. The person doesn't have to be voted on by a board. They don't have to be sworn in. And as a matter of fact, there's no training requirements, although we certainly recommend that they attend training, just like you are here today with our webinar. Agencies can come up with their own local rules for administering their open records program as long as it doesn't conflict with the right to know law or any rules promulgated by the Office of Open Records. Let me give you a quick example. The right to know law says that agencies may accept anonymous requests. Okay, well, there's another law in Pennsylvania. It's called the Statutory Construction Act. And that law more or less says that because the word may is in there, it also means may not. So looking at a local rule, an agency could have a rule in place that says, we will only accept right to know requests where the person is identifying themselves. We will not accept anonymous requests. Pardon me. Okay, well, that is consistent with the right to know law, and you could very well have that policy in place. Okay, so there's one example. You can also come up with your own right to know forms, and many agencies do. You know, they like to have their seal at the top, perhaps contact information for their arrow. They could have some of those rules, those local rules and policies on their form, whatever. Some agencies will simply link to the state form, and that's fine. It's on our website. There's nothing necessarily unique about it, but you're welcome to do that as well. So you could have a rule saying that we'll only accept right to know requests that are on our form, but you must also accept the uniform state form, the request form. Okay, so if someone comes in with the state form, you must accept that as a valid right to know request and follow through on the process. And then finally, we ask that you notify us here at the Office of Open Records who your arrow is or who your arrows are. And that brings up another important point. You can have more than one right to know officer. You can have more than one arrow. And again, many agencies do. They may have one person covering the administrative side, and then a second arrow, say for the police department. Okay, and that's completely acceptable. Just look at it from the public's perspective. Make it clear, who do I give this right to know request to? Who is the appropriate person? Okay. So notify us who your arrows are, because on our website, we maintain a database of all the arrows statewide, but it's a voluntary system. So we realize, people move on, they retire, they get promoted, whatever. So in order to keep our records up to date in our database, we're relying on you to help us out. Check it out. Make sure your records are up to date. If not, there's a form that you could fill out, email it to us. We'll verify it, and then we'll update the database. And this database, you can check it out. The public has access to it. And it's also important because if we receive an appeal against your agency, it's the contact information on the database that we reach out to, okay, with the appeal information. So it's important that we keep this up to date. You're also required to have postings if you're subject to the right to know law. And it would be either on your bulletin board, or if you have a website, it would have to be on your website as well. And the intent of the postings is to educate the requester. Again, look at this whole process from the public's perspective. Okay, so make sure that everything you have is more or less written from that perspective, and your life's going to be easier when it comes to administering your open records program. So you have to have contact information for the arrow. Again, I got this right to know request. Who do I give it to? Contact information for the applicable appeals office. And in 99% of the cases, it's going to be the Office of Open Records. I'd recommend that you simply put the URL for our website, because appeals are processed electronically. They're accepted electronically. They go into our docketing system and processed that way. So having the URL for our website is probably the best thing you can do there. Then you have to have a form available so that if the person filing the request doesn't have a form, you have one that you can give them. And then finally, list any of those local regulations or policies that you may have unique to your agency, again, so that person knows what the playing field looks like before they enter the game. Okay, the easier you can make this, the easier it's going to be for you in the long run. Okay, some things that you cannot do with the right to know law. The first is that you cannot limit the number of records or number of requests that a person submits within a specific time frame. You can't say, ma'am, I'm sorry, you've already filed 3 right to know requests this week. That's all we allow. If she's inclined to file a dozen requests this week, the law allows her to do that. Also, you cannot compel a person to tell you why they are filing a right to know request. Let me get a sip of water here real quick. You cannot deny a request based on the reason or what you think the reason is. Now, let me go off script here a little bit. The majority of requesters are legitimate. They submit a right to know request because they are looking for a record. But we also acknowledge that there are some folks out there who have weaponized the right to know law. For whatever reason, the relationship between them and the agency has broken down, and they have decided they're going to be a pain in the neck. And one of the ways they're going to be a pain in the neck is by filing a lot of frivolous right to know requests. My experience is learn about the payment side of the right to know law, and that will make your problem go away in 99% of the cases. We do a webinar on payment issues in the right to know law. I would suggest sitting in on that, okay? But get familiar with the payment side, and these people who have weaponized the right to know law, in most cases, will go away and won't be a problem for you. Okay, off my soapbox, back on to the script here. And I see someone is asking, are we planning to do a training on the appeals process? At the end of this session, I'll touch on the appeals process a little bit. It doesn't go into great detail. The webinar hasn't been done for a while, but there's one on writing good affidavits that our deputy director does, Nathan Byerly. That's very good. If you have questions, I would suggest reaching out to him as well. Maybe we can talk him into doing the webinar sometime soon. Also, during when we do our annual training, we usually touch on the appeals process. But hang in there, and I'll get to it at the end. And if you have any specific questions, it would be a good time to type them in at that point. And I'd be happy to hopefully address your questions and get you steered in the right direction. All righty, moving on. I like to portray the right to know process as an obstacle course. And on this obstacle course, there's the start. There are 2 hurdles, and in front of the second hurdle, there are 3 hoops. So we got to make it through this obstacle course in order to determine if a record is in fact public and should be released through the right to know process. So let's talk about this. First, many events have what's called a time standard, meaning in order just to enter the event, you have to be, at a certain level. So let's talk about the deadlines. The first deadline, when you receive a request, well, let me just note here that when you receive a request, you want to note the date that you receive it, because that's the start, okay? And it's important because you come up against the first deadline. And that deadline is you have 5 of your business days to provide an initial response. Now, what does that mean? Well, your business days, you may not be a Monday through Friday operation. Okay, so a business day wouldn't include a Saturday or Sunday. It wouldn't include a holiday. It wouldn't include, a weather closing. Okay, and if by chance you're not open 5 full days, well, the business days would be the days that you are open to the public to conduct business. So let's say you're a small township and maybe you're only open 2 days a week, hypothetically Monday and Tuesday. So you receive a right to know request today. Well, next Monday would be your first business day. Then you've got Tuesday. Then you go to the second week, Monday, Tuesday. Then you go to the third week, Monday. At the end of that 5th business day, that third Monday, that's your 5 full business days. That's when the initial response is due. Okay. And you want to maintain copies of all your requests. Now, this gets a little confusing here, but bear with me. The right to know law says that you maintain all your right to know materials for 30 days or until all appeals have been exhausted. Now, if you've got an appeal working its way up through the court system, that could be several years before it gets to, conceivably the Pennsylvania Supreme Court. So you want to make sure you have everything available. But then you have another law. It's called the Pennsylvania Municipal Records Act, where if you're a township or a borough or a city and you've adopted that act, that says you hold on to everything for 2 years. So whichever is longer, the appeal or the 2 years is what would apply. If you have no appeals, after 2 years, you can dispose of any right to know materials for any appeals that, or I'm sorry, for any requests that have been resolved one way or the other. If they're inactive files, you can dispose of them per your records retention cycle, which is something that you would learn about when you adopt the Municipal Records Act. That particular law is administered by the Pennsylvania Historical Museum Commission. I would recommend reaching out to them. Check out their website, Bureau of Archives and History, State Records Center, Municipal Records, and a very good resource for figuring out how long you should hold on to various records in your agency. Not just right to know stuff, but everything that your agency typically touches. Okay? Now, let's say that for whatever reason, you're unable to provide an initial response within that 5 business day window. The right to know law allows you to then take a 30 calendar day extension. Okay, calendar day is different from a business day. Calendar day does include Saturdays and Sundays. It does include holidays. It does include days, weather closings. All right, you simply add 30, you pull out your calendar and count 30 days from this, what would otherwise be the 6th business day. And that's how you arrive at the end of your 30 calendar extension. But for the extension to be valid, there are some conditions that need to be met. First, it needs to be invoked within the 5 business day window. You can't wait until the 6th day, suddenly realize, oh, I forgot to respond. Oh, well, we'll just take the extension. Unfortunately, you have denied the right to know request by default. It's what's known as a deemed denial in legal circles. Okay. You need to notify the requester in writing that you're taking the extension. And if they submitted a right to know request by email, well, responding back by email is fine. You need to provide a reason why you're taking the extension. And if you go to section 902 of the law, it actually lists 6 reasons, and pick the ones that are most appropriate. It could be, we keep these records off-site. It's going to take us longer than 5 days to go through them and see what's appropriate to give you. Or we want our solicitor to review this to make sure we're not giving out records that we otherwise shouldn't. Okay. Then you provide the date that the requester can expect to get a response. Usually that's the 30th day of the extension. Then an estimate of any costs. This is not a hard quote. It's simply an estimate of any costs that the requester can expect to incur. So you've got the 5 business days, and then you have the 30 calendar days that get tacked on to the end of it. Just don't get into the habit of automatically invoking the extension if you don't need to. If someone is requesting what obviously is a public record and it's readily available and you can provide it within the 5, or provide the response within the 5 business days, then you should do that. Okay. It's just good customer service, good government service. All right. And, nothing upsets people more than to request what's obviously a public record, not hard to get a hold of, and their first response from the agency is, well, we're going to take 30 calendar days. It just throws cold water on everything. Sometimes it's done mean-spiritedly, and it just upsets people. Okay, so please don't do that if you don't have to. All right, moving on. We're up to the first hurdle, and this hurdle is asking a question. Is it a record? Okay, that seems rather obvious though, but let's get into this a little bit more. When someone is researching a law, trying to figure out what it involves, a lot of times what I recommend is take a look at the definition section of that law. Because if you encounter vague language or some, potentially conflicting language, a lot of times the answer can be found in the definition section. The right to know law is no different. What is a record? Well, you go to the definition section, and sure enough, there's a definition of a record. Any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, Okay, key phrase highlighted in red there. Documents a transaction or activity of an agency. Okay, what does that mean? Let's try and translate this into English. It means that a record is a communication about what the agency does, what the agency is responsible for. Okay, so let me use an example here. Let's say I send an email to one of my colleagues. I hear a new restaurant's opened up downtown. You want to meet for lunch tomorrow? Or, hey, how do you think the Eagles, what do you think of this so far, their undefeated season? Or, I'm picking up a gallon of milk on the way home tonight. All right, all fairly common communications, but none of them have anything to do with documenting a transaction or activity of the agency. Therefore, they do not rise to the definition of a record. They don't make it over the hurdle. They're off the course. I don't have to worry about common communications like that are sent all day long being released through the right to know process because they are not considered records. They don't make it over the hurdle. They're off the course and would not be considered responsive to a right to know request. Okay, everyone understand that. Now, questions popped up. Does the timer start when the agency itself receives the request or the actual arrow receives the request? Okay, that is an excellent question. It is defined, well, first offhand, this is a provision in the right to know law, but there's also a court case, Donahue versus the Office of the Governor, that establishes case law on this. And the answer is when the arrow receives the request. So if the arrow is out sick or on vacation, the clock starts ticking when the arrow comes back and actually receives the request. Now, if let's say the arrow is on vacation though, I recommend communication with your requesters to let them know when the clock does start ticking so that there's no misunderstanding. All right, and like our office would have like an out of office reply. Actually, our office has 3 people with access to that particular mailbox so that when a right to know request comes in, the arrow is going to get it right away. But if by chance no one's available, they receive an out of office reply letting them know that the request will be processed upon the return of the arrow and give the specific date when they're expected so that everyone's on the same page there with how they're counting the days. Another question, does an email between a township and a developer regarding a new development constitute a record? We'd have to look at the specific circumstances. I think you're probably getting a little bit ahead of me. But in general, I would say that would probably be considered a record of the township. Okay. But, I don't want to paint with too broad a brush here because there's always exceptions to the rule given the specifics of the situation. Okay, but in general, I think you could agree with that in saying that it probably would be considered in the public domain. But that might best be addressed by a solicitor or your attorney. Okay, let's move on here. So we've determined that it is a public record. It is dealing with a transaction or activity of the agency. Now on our obstacle course, we come up on the second hurdle. But before we can get to the hurdle, we've got 3 hoops that we've got to get through. The first hoop, we've got to answer the question, do any exemptions apply? And if so, are we going to invoke them? Okay, what the heck does that mean? Well, within the right to know law, and this is probably the most powerful tool you'll encounter, there are 30 exemptions Okay, and they're all listed in Section 708B. An exemption is a definition of a record that the agency can withhold from the public, provided that record falls within that definition, and if the agency chooses to do so. Okay, so we look at these 30 exemptions, and they cover an incredibly broad spectrum of records. For instance, there's one that says if by releasing this record it would put someone in physical harm, okay, then you can withhold it. There's another one that says any record of discipline that a public employee may have, okay, that can be withheld. If there's one that says if by releasing this record it would provide information about a minor, okay, that can be withheld. Another one, anyone's academic transcripts, okay, that can be withheld. That's private. It's considered confidential. All right, so you would take a look at what's the person asking for. Is there any chance that what they're asking for falls within one of these exemptions? If it does, then you have to ask yourself, are we going to invoke the exemption, or would it be okay to just go ahead and release it? Because remember what I said, the right to know law is not a confidentiality law. It does not mandate that you withhold records. Rather, it just says that if a record falls within one of these exemptions, you have the discretion to withhold it if you choose to do so. Okay, so that's the question that needs answered here. Is there an exemption that applies? And if so, are we going to invoke it? If not, then we go to the second hoop. And this hoop is a little more difficult because here we need to answer the question, are there any federal or state statutes or possibly a judge's order that says these records are not public? Now, here you need to be aware of whether or not there is another law, okay? And you'd be surprised at the number of laws that have confidentiality provisions in them. Let me give you a couple examples here. For instance, police departments they need to follow a law called CRIA, the Criminal History Records Information Act. This law basically says that there is a body of records that can only be shared within the law enforcement community. And you cannot share these records outside of that community. Otherwise, you'll face possible criminal sanctions. Okay, so if I look at the right to know law, and let me give you an example. Let's say that our township has a file where they keep records of suspected gang activity. All right. The right to know law has nothing in it regarding criminal intelligence information, but CRIA does. CRIA says you cannot give out intelligence information. So you receive a right to know request for a copy of this file. In denying it, there's nothing in the right to know law that I could refer to, but I would refer to the privacy provisions in CRIA that basically says I cannot give out criminal intelligence information. By using this other law, I am meeting my legal burden for not giving this out. Another example, school districts should be familiar with a law called FERPA, the Family Educational Rights and Privacy Act, which protects individual educational records. Okay, if by chance a school district gives out that information, they could face sanctions that could impact their federal funding. So they would cite the appropriate provisions within FERPA for not giving out certain educational records. Someone has asked the question, what about HIPAA? Well, any health-related information, whether it be covered by HIPAA, FMLA, the Americans with Disabilities Act, would be considered confidential. And if someone were to, and typically FMLA covers employers more appropriate than HIPAA does. Basically HIPAA covers health providers. FMLA, and I'm saying this because we also have a webinar that we just did 2 weeks ago on laws that protect information. And we covered these, the alphabets of health protected laws. And FMLA is the one that most public employers need to be concerned about with protecting leave information, serious health conditions, and the like. Okay, so if someone were to submit a right to know request that might refer to medical records for staff and even leave records for staff, you would use the confidentiality provisions of one of these laws, whether it be HIPAA, FMLA, ADA, and the like, as your legal basis for denying access to those confidential records. Okay, so that's your second hoop. Are there any other laws? And like I said, you'd be surprised. And usually what these other laws do, they say you must withhold this information, which is different than the right to know law, which says you can withhold this information. Okay, these other laws usually give you no choice. They mandate, they remove the discretion that the right to know law gives you, and they say you must withhold these records. And usually there's some sort of sanction involved if you violate those confidentiality provisions. Okay, so now we come up to the third hoop in front of the second hurdle. And here we need to answer the question, is the record protected by privilege? Usually we're talking about attorney-client privilege here. Yeah, there are other types of privilege, but for our purposes, attorney-client privilege, attorney work product. Any sensitive information shared between an attorney and their client is typically protected by attorney-client privilege. And for our purposes, we're talking about your solicitor or your counsel and senior management, whether that be borough council, your township supervisors, your township manager, whatever, okay? Those communications, whether they be emails, memos, or the like, are protected by attorney-client privilege and would thus be off the table. Now, a lot of times people will submit right to know requests to get copies of the invoices submitted by solicitors. They want to know how much we're paying for legal services. Okay, valid question. So what you need to do is take a look at the invoices and determine whether or not they are of such detail that you can determine legal strategy. If not, well, then there's an invoice with least under the and typically a solicitor might say, for this quarter, I'm billing you, X number of hours. No detail, no legal strategy, record. All right, audio is getting low. Okay, let me raise my voice. I'm probably leaning back in my chair too much here. Okay, so what about, though, if the solicitor goes into some detail where saying, for this month, I'm billing you 6 hours for research that I'm doing on this particular body of case law in response to this particular lawsuit that we're dealing with. Or I'm billing you X number of hours because I'm interviewing these potential witnesses for the court case that we're facing at the end of the month. Okay, if by looking at this, I can kind of figure out the agency's strategy on this particular court case, then yeah, I probably could claim attorney-client privilege and withhold those records, withhold the invoice. When in doubt, I recommend simply go to your solicitor and ask them, is this protected by attorney-client privilege? Let them decide. If there's still some dispute about it, the requester can always file an appeal, and the appeals officer will sort it out, and they'll determine whether or not attorney-client privilege applies. The other thing that you need to be aware of is that if privilege is broken, the record becomes public. Okay, so what does that mean? Let's say that the solicitor provides an email to all members of council, okay, providing some legal advice. But then one of those members goes around and puts the copy of the email on their Facebook page. By making the privileged information public, you have broken privilege and it becomes a public record. Now, whether or not the rest of council sanctions that member in some way, that's outside of the right to know law. But for our purposes, privilege has been broken, thus it no longer applies. Okay, but we're talking about right to know process here. The third hoop is the record protected by privilege. If it is, again, it's off the course, okay? The record is not public and it doesn't get released. But let's say that all three conditions, all three hoops, we've determined no exemptions apply. There are no other laws that say these records are confidential. It's not protected by privilege. At that point, we can jump over the second hurdle. And when we do that, we're saying this is a public record and it's released in response to the right to know request. Okay, so we're going to release these records. Well, the right to know law is not free, okay? There is a payment side to the law, like I was talking about earlier. So just real quick here, let me cover a couple points. First offhand, this is an important one. The agency is only required to provide the record in its current medium. Okay, in Section 701, I've kind of paraphrased that, but let me translate this into English. It means basically hard copy versus electronic. So that if you have a record that you only have in hard copy, you are not required to scan it in order to produce an electronic version of that otherwise hard copy only record. Okay, only if you have the record already in electronic medium, then would you be required to provide it electronically. And that's important because you cannot charge for electronic records. Okay, but the takeaway here is you're not required to scan in hard copy records if you haven't already done so. Now, you cannot charge for electronic records. And there is also the provision where a person can request to inspect the originals. If they do so, and you've granted that, they can come in and go through the file and you can supervise that. I mean, the person comes in when it's convenient for you to allow them to do so during normal business hours. You can supervise the inspection, meaning you can watch to make sure they don't steal anything, alter. However, if they pull out their cell phone camera and take a picture, they're allowed to do that. They're allowed to make their own copies. Now, you cannot charge for labor. You cannot charge for redaction, meaning if you have to black something out, like a sensitive piece of information, like say a social security number, well, you can't charge for that. And if you have determined that there should be some sort of legal review, you can't charge for what your counsel or solicitor charges you. That's simply considered the cost of doing business for government under the right to know law. You can charge for actual costs like postage. Okay, if someone wants the records mailed to them, you can charge, for the copies that you've made, and you can charge for the postage. Whatever your meter says that it's going to cost to mail that package to them, you can add that to your invoice. Okay, I recommend no surprises, and I kind of hinted at this earlier. Pardon me. There is nothing in the right to know law that prevents you from reaching out to a requester to clarify, number one, what it is they're asking for, and number two, to let them know how much you think this is going to cost. Because some people mistakenly think the right to know law is free, and we know it's not. So let's say you get a right to know request, you do a quick estimate, you think it's going to cost them about $30. So you pick up the phone and you say, hey, we think it's going to cost about $30. You okay with that? Most legitimate requesters are going to say, yeah, okay, go ahead and proceed. Some are going to say, wait a minute, I thought this was free. No, I'm not going to pay the $30. I'm withdrawing my request. Well, you just saved yourselves a bunch of work there and making a bunch of copies, okay? Communication is good. Clarify any ambiguity so that everybody's on the same page. Now, ideally, it's a mutual exchange. You provide the records and they provide payment at the same time, everybody's happy and we move on. But the right to know law says that records are provided upon payment. That means that the person pays first and then you provide the records. And let me also clarify that when we're talking about the deadlines in the right to know law, those are for when the response is due, not the provision of the records. Okay, there's a difference. 5 business days, the 30 calendar days, that's when the response to the requester is due. Your response might be, we are granting these records, or we're granting access to these records, but you need to pay us. And once we receive payment and your check clears, then we'll provide you with the records. You see the difference there. The provision of the records can fall outside of the deadlines. The right to know law doesn't address that. And it's considered to be a reasonable period of time, which is somewhat subjective. Usually it's only a few days, but you need to recognize that difference. Okay. And then there's the issue of what if we receive a request, we do a quick estimate, and it's going to exceed $100? Well, you can demand payment in excess of $100 before you begin processing the response. Okay, I like to view it as a kind of a security deposit to make sure you don't get stiffed for a really big response and then the person doesn't pay you for it. That way you have their check on hand and you settle up on the exact amount when you provide the actual records. Then there's a thing called record discard, which I'm just gonna pass over it because it doesn't happen all that much. But basically, if someone says, I'm going to come down and pick up the records, you have to hold on to them for 60 days. After 60 days, you can get rid of the records. Okay, and then finally, let's say that there is a cost involved and you provide the records, but the person never pays you. If there are outstanding fees, you can deny any subsequent right to know requests because those fees are outstanding. And there's no statute of limitations on that. It doesn't go away after a month, doesn't go away after a year, doesn't go away after 10 years. If there are still outstanding fees, you can deny processing any further right to know requests for that person. Just make sure you've got all your paperwork in order, okay? Because they can file an appeal because you are denying for outstanding fees, okay? And the appeals officer will ask for all the appropriate records. And if everything's in order, there's a very good chance they will agree with you and uphold your decision. Okay, let's say, however, that after going through the process, the person didn't make it through the obstacle course and you're denying their request. There is a format that you need to follow for your denial letter. First is that you describe the records. Now you're thinking, oh, that seems rather obvious, but sometimes it's not always 100% clear what the person is asking for. And if you haven't reached out to them to clarify, it really helps if you put it in your own words. We believe you're asking for these records. Okay, so that's the first paragraph of your denial letter. Then you need to put down the legal and factual grounds as to why you're denying. What is the exemption that you're invoking? What is the other law that is saying these records are confidential? And make that nexus between the records that are being sought and the law or the provision of the law that you're using as your legal basis. This is where the rubber hits the road. Okay, this is where you're making your legal argument as to why these records are not public. Then you put down the name, title, signature, and business address and contact information for the arrow. because this is the person legally responsible for responding, if you remember what we said earlier. The date of the response, that's important because another deadline suddenly kicks in where the person has 15 business days to file an appeal. Usually, those appeals are filed with the Office of Open Records, like we said earlier, okay? So you detail all of this in your denial letter and send it off to that person. Now, I promised to talk about appeals here briefly. If you deny it, like I said earlier, the person has 15 business days to file an appeal with the Office of Open Records. And it's the Office of Open Records business days now. It's a Monday through Friday operation. Yeah, they are closed for state holidays and the like, but it's 15 business days. Usually, the best way for a person to file an appeal is right on our website, where there's a form system that makes it fairly simple for them to go ahead and file their appeal online. We look for 4 elements. First is we need a copy of the original request. We need a copy of the agency response, provided there was one. Then they need to provide a statement as to why they think the records are public. And then finally, a statement addressing why they think the agency denial is incorrect. If any of these 4 elements are missing, we'll issue what's called the deficiency order. And the person has a couple days to correct that deficiency. If we get everything, then the appeal gets docketed. Docketed simply means that it gets assigned a 4-digit code. It's usually AP 2022 dash and then that 4-digit code. It gets assigned to an appeals officer, and a packet gets sent out, usually by email, to all the parties. The packet is mainly for the benefit of the agency because it details, hey, we've received an appeal against your agency. Here's what you need to do. Now, my advice to you at this point is if you are an agency employee or if you are an ARO and you receive notice of an appeal from our office, run, do not walk to your solicitor to notify them that you have an active right to know appeal, because there are very tight deadlines built into the appeal process that your attorney must address. As an ARO, you're not expected to know how to respond to an appeal. Your solicitor is. Everything that I've detailed in this presentation up to this point, I would couch as an administrative process. Once an appeal gets filed, it is a legal process. And suddenly, the Office of Open Records turns into what the Supreme Court of Pennsylvania has defined as an independent quasi-judicial. You become a court, and you must follow these legal processes in order to make sure that you don't get dinged for a procedural error, and that the Office of Open Records has every opportunity to rule on the merits. Okay, so probably the most important thing that I'll talk about here this morning is this point. You receive an appeal, give it to your solicitor immediately, because they're suddenly under a very tight deadline to get the paperwork filed for your legal rights. Okay, the product of an appeal is what's called a final determination. These are legally binding final orders issued by our office. They look just like what you would see coming out of a court as far as the written ruling goes. They're typically issued after 30 days. We may request an extension given our workload. And if we do so, as a personal favor to me, I would ask that you grant that extension, because it's not done haphazardly. And all of these final determinations are available on our website in a searchable database. They're also available through your legal services, such as Lexis and Westlaw. Okay, regarding redactions, can agencies implement their own policy to only provide redacted records in physical form, even if electronically redacted, to prevent the circumvention of the redactions? Okay, if I think what you're saying here between the lines, Chris, is that if you have security concerns about how redactions are made using an electronic tool, at this particular point, I can say you can attempt to go with a manual redaction and require that it be on hard copy. However, I should let you know that this is an evolving area of right to know where probably we're going to reach a point where we're going to say if you have electronic software like the Adobe Office suite where you're able to do electronic redactions, then you must do that. At this point, I think the word we're using is should rather than shall. So we're saying if you have electronic software, you should affect the redaction electronically rather than you must do so. However, that point is probably coming where we're going to say you must do it, and the courts may dictate that. We did quite a bit of research on this because initially we had electronic redactions where we actually had someone, they were able to break the redaction and see what was behind it. That was many years ago. We actually did some research, though, consulted the FBI and the like, and we've determined that there are nowadays a number of electronic redaction software packages that are secure and that the FBI has certified as secure. So that's the direction that we're headed in, okay? Not a black and white answer, but I think that's providing you with good guidance at this point. Okay, good question. Back to final determinations. You're welcome to take a look at our website. It's like 30,000 and counting at this point that you can search through. You can search based on your municipality. You can search based on your agency. You can search, simply put in a random text string, and it will tell you, it will bring up all of the appeals that our office has ruled on. Okay. There also is the option of mediation. We have trained mediators on staff where sometimes rather than going through the typical adversarial process, you just get the impression that if the parties would just talk with each other rather than at each other, they might reach a solution here. And when someone files an appeal, they're asked, would you be interested in mediation? And then when we send out the appeal packet to the agency, we provide an explanation, ask, would you consider mediation as a possible? And if both parties indicate affirmatively, then the case gets assigned to a mediator. And sometimes all it takes is a conference call where you get everybody together talking about the case and they're able to arrive at an amicable arrangement. And the case goes away. Everybody's happy, okay? Right now, I haven't looked at the metrics lately, but it had been like 50% of cases that get assigned to mediation get resolved. If not, then it just gets assigned back into the normal process. Okay, our decisions can be appealed to higher level courts. For a local agency, it would be your county court of common pleas. It has to be done within 30 days. And you have to notify the Office of Open Records that you are appealing our decision. Either party can appeal. And the Office of Open Records is not a party to the appeal. Rather, we are the lower level adjudicatory body. But we'll do one of three things. We'll either simply monitor the case. We may file briefs with the court for purposes of educating the judge about the right to know law process and why we ruled the way we did. And thirdly, there are those limited instances where we may ask to appear before the court and help argue the case. That happens every so now and then, usually at the Commonwealth Court or Supreme Court level, not so much at the county level, but occasionally it happens. Okay. So we've reached the end of the presentation. If you have any further questions, now's a good time to get them in before we log off here today. Or if something comes up after we log off, feel free to reach out to our office. But in the meantime, I want to encourage you to take a look at our website. It is an excellent government website. It gets updated 6 days a week. New court decisions and the like. Okay, questions popped up. Do right-to-know requests only cover records from the time filed and backwards, or if the requester asks for anything that comes in from an outside agency in the future? Good question. It's only from the time the request is filed back to as far as they would indicate on a finite time frame. Okay, you cannot ask for records that have yet to be created. Okay, and occasionally you'll see that. Someone says, I'd like meeting minutes, and you might as well just send me the meeting minutes from here on out for all future meetings. Okay, that's not a valid right-to-know request because the record that they're asking for doesn't exist yet. Okay, so you can deny it. You know, the argument comes down to possession. We do not have possession of the record that you're asking for because it has not yet been created. That's the logic that's used there. So another good question there. You can't ask for a record that you don't have because it doesn't exist yet. Okay, but back to the website, all kinds of good resources on there, training guides for the public in general. For agencies, you know, if you happen to be an Arrow, we have an Arrow guidebook, 78 pages long, with all kinds of helpful information in there that you can refer to. But if you have any, you know, let's say you encounter some unusual situation that you just don't know what to do, contact our office. And we have administrative staff that will help you out. And if they don't have an answer for you, you know, then they'll refer it to some of the senior staff, and we'll try and get back to you usually within a 24-hour window. And we're very good about that. Okay. So we're at the end here now. If there's no further questions, I'm going to log off, but I want to thank you for your participation today. We'll be back in 2 weeks, and I think in 2 weeks we're doing basics of the Sunshine Act, which is the public meetings law. Okay, so logging off. Thanks again for your participation, and have a good rest of the day.